The following program is made possible in part by the Dayton Bar Association.
Good evening and welcome to You in the Law. I'm Mike Monta, your producer and host for tonight's program. And tonight we're going to be talking about probate, estate planning, and maybe even the new maybe rolled out Trump tax plan. Joining me as guest on tonight's show, an expert in the field, Mr. Tom Baggott, and former magistrate and estate planning attorney and whatever. We'll find out. And we're going to be discussing, as I said, the probate process, estate planning, taxes, and any questions that you, the viewer, calls in with. And we'll talk about that in a minute. Before we start our discussion, let me remind you that You in the Law is a monthly presentation produced here at the studios of the Dayton Access Television. DATV is on Channel 5, and it's the public access channel of Spectrum cable network here in Dayton, Ohio. And we are cable cast through the auspices on tape delay through Miami Valley Cable Council. And in the suburbs, I believe you can also get this on Channel 6. The executive producer for our program is former domestic relations judge Mike Brigner. We also stream live on datv.org, so you can catch the program that way also. We are live and in color, and this is an audience participation show. And occasionally you'll see the number, which is 223-5311. And it'll come on the, right below my face there, I think. There we go, yeah. So if you do have a question, and you should, give us a call at that number. So one other thing, we're sponsored again by the Dayton Bar Association, and we'll be talking a little bit about them as the evening goes on. Bill Wheeler was the executive director, and he just retired, and we're hoping that maybe the new director will call in with a question about our program. So let's turn to our guest, who is Mr. Tom Baggott, and he's going to tell you a little bit about his background and familiarity with tonight's topic. And good evening, Tom.
Good evening. Thank you, Mike. Well, I was admitted to practice October the 1st of 71.
1971.
1971.
Okay. All right.
And worked for the probate court off and on for a number of years. My practice before I retired was a probate practice. I did estate planning, wills, trusts, guardianships, things of that nature, and the administration of estates and guardianships.
Okay. And as we were talking just before the program, you are from an illustrious legal family. Tell us a little bit about that. You're the lone survivor now of that family. So. Well,
yeah, my grandfather's uncle started practice in 1850, June of 1850, and then his nephew came to live with him when his family died in Louisville in the influenza epidemic. My father, my uncle, my brother, I practiced law. My son practices in Nashville, so I got to 5th generation work.
So you're not the lone survivor. You have another Baggott working within the country here too.
Yes.
Okay, well that's great. And your dad and brother were, I don't know if it's legendary, maybe legendary, but renowned trial attorneys
yes.
throughout the century.
Yes.
And we're glad to have you here talking
Oh,
tonight.
I'm glad to talk about them. They're great folks.
Okay. So we're going to talk a little bit about estate planning and probate, and they kind of go hand in hand, I guess.
Yeah.
And we can talk about that. And just last week we had a possibility of a new tax plan, so maybe taxes go hand in hand with estate planning, and that's part of it also. So who needs an estate plan, and what does it entail?
Everybody needs an estate plan.
And why is that?
Well, otherwise, the state says where your assets go and to whom they go, and that isn't always the way that wants to be done.
Okay.
It starts with a will. And a will, the testator, the guy who writes the will, says where he wants his assets to go and to whom and in what amount.
All right.
Generally, it goes to the wife and the children, but other things can happen. A general power of attorney is generally done these days, so that if the person who writes the will becomes incompetent or just unable to take and transact business, the attorney in fact, the person with the power of attorney, can take care of that business. And you do a living will, and a living will is a document which says, I want so-and-so, Mike Monta, to make medical decisions for me if I cannot.
Mm-hmm.
And also a durable power of attorney for health care, in which it says Mike Monta can make medical decisions for me, but I want the plug pulled. I don't want to be on artificial.
Mm-hmm. And that's on your living will, right?
Yeah.
Yeah, okay.
So it's that whole 4 documents is a good start.
All right.
If, unfortunately, since we all go on to the next life,
Right.
those documents make it easy for the administration of assets in the estate, tells the kids or whoever what you wanted done and how you wanted it done, and it helps them not get into fights with one another.
Okay. So let's talk about a typical Mr. and Mrs. Dayton and their 2 or 3 children. They don't have a will. They might be between 30 and 40, 50, sometimes even later than that. What should they be thinking about, and how should they approach this?
Well, I think the first thing they should think about is who's going to be the guardian of their children if something should happen to the both of them before the children are able to care for themselves.
All right. Well, they're still minors.
Yeah, well, they're still minors. To determine what assets will go where. You know, generally, husband gives it all to the wife, wife gives it all to the husband. But what happens if they're both gone and the children need it? Well, then they can direct how the children's money will be used and how it will be spent.
All right.
Because the kids generally are going to get Social Security benefits.
Okay.
And that's, so they won't need all that money right away. But if whoever the guardian is should get some kind of monetary relief for taking care of them, because the kids need clothes, they need food, they need a place to live.
Right. So, all right. What should the people who are thinking about starting the estate plan, and I'm guessing you're saying start with a will, and then work on to those other documents which you may need during your lifetime. The will takes effect after you die, of course.
That's right.
And that's what you're thinking about, not being around forever, I guess.
Yeah. Well, that's true. You and I, at some point in time, are going to step into the next life.
Okay, well, we'll see.
Not for a long time, we hope.
Right.
But it is important to have things, I call it in apple pie order, before you need them. The will is an ambulatory, as you noticed. It doesn't speak until somebody's gone. So it can be changed. But as circumstances change, the document can be changed so that, well, maybe we don't need a guardian anymore for the kids. So maybe we want to give something to charity if things have worked out well. But in the Ohio Revised Code now sets forth who gets what if there's no will. It always has. Right. To my recollection, anyway.
That's the legislative body thinking that they know what the typical testator, the person who dies, how they would want to distribute their money and who they would want to have administering their estate. Correct?
Yes, called the Statute of Descent and Distribution. And in a lot of instances these days, the surviving spouse gets everything if the surviving spouse and the decedent have children between them. You know, they're our kids, so to speak. Right. So you may want the kids to have something now, or maybe not. What if, when you get into second marriages and yours, mine, and ours in the children's department, it gets to be very complicated.
Now, one of the things you said was that, and I think our viewers would be interested to know this, that just because you do a will doesn't mean that's the end of it. You could change it as many times as you want.
That's right.
Okay. And oftentimes, I guess people do as their lives and circumstances change.
That's right. You know, there's a situation theoretically which could happen that the testator is the only one left. And where do they want their assets to go? Well, there are various charities that would be more than happy to be a beneficiary of that. And it can do a lot of good. That kind of asset can help other people or other situations that they could not do for themselves. Or, you know, or the Philharmonic, for instance. They like to make music, but they never make any money.
So a music lover might be thinking about that if he has no heirs.
Yeah.
Okay. And places like, I guess, the Salvation Army would be interested, or the Dayton Foundation, places like that.
Yes.
Okay. All right. So a lot of times people think about this when they come to my office. They a lot of times will say, "We've been thinking about this for years." In other words, just because they are thinking about it doesn't mean they do something about it right away. And it might be because the ordinary, and I don't mean that they're ordinary people, but the general folks are not acquainted with the legal system. So generally, and need to think about finding an attorney who does this. So what would you suggest folks do when they've got an idea of what they might want to do with a will and guardianship, things like that?
Well, if they know a lawyer or have friends who have lawyers, they might get a recommendation. You can call the Dayton Bar Association. They have lists of lawyers in different areas of specialty, I'll call it, and they can direct them to those folks so that you can get working on a plan.
Okay.
Most people, I get the perception they don't want to think about a will because that means they're thinking about their own untimely demise.
Right.
And they don't want to think about that. None of us do.
Right. But it's not going to get done until you actually
Yeah.
take that first step, make a call. What do you suggest to people? Let's say they were going to come to you as their attorney. We want to make a will and talk about some of these other things is usually what happens, I guess.
Yeah.
What information is the lawyer looking for from the person who wants to design these documents?
Well, the first thing I ask for is a list of their children, their children's addresses and phone numbers. Next would be a list of assets. One of the big assets these days is retirement plans.
Okay.
Now, retirement plans, if it's an IRA or a 1041, the spouse is required to be named the beneficiary. That's the first wife, let us say. Not necessarily the second wife. And that a lot of times is a big asset. The home is generally the biggest asset that most people have. The surviving spouse has a right to live in that house for a year, but it may be a burden, and sell it. And so the executor, if named in the will and given a power of sale, can sell it. Otherwise, if there's no will that allows that, then you have to go to probate court, set up an administration, do a bunch of paperwork called a land sale, which wastes a lot of time and is very expensive. It's an expense that isn't necessary if you draw a will.
Okay, we're going to take a very short break. We're about 20 or so minutes into the program. We don't have any commercials, so there's our number for if you want to call in and talk about estate planning or any of the things that Tom Baggott is talking about tonight and get some answers. We are sponsored by the Dayton Bar Association, which has been in existence since 1883. And at that time, let's see, the mayor was John Miller.
Never
heard of John Miller? He might have been around when one of the old Baggotts was around.
Probably, yeah.
Chester A. Arthur was the president back then, former Port of New York Authority director, and kind of fell into being the vice president and became the vice president when poor Garfield was shot and subsequently died, and had a nice term in office as an accidental president. DBA is not accidental, though. We're doing a lot of good work, and I have a list of some things here, and I'm going to tell you what we do. And you talked about one of them was a lawyer referral service, and this is where referrals are made to local lawyers here in town on specific areas that you, the viewer, when you call the Dayton Bar Association, they'll refer you to somebody. And the number to call for them is 222-6102. The number of the Dayton Bar Association itself is 222-7902. There they are. They're right on your screen. So call them, and they can direct you if someone else hasn't referred you to someone. The Dayton Area Bar Association website is www.daybar.org. We also have a thing called Find a Lawyer, which is, I guess, similar to that, and that's got a website. If you don't like talking on the phone, I guess the website is the thing for you. www.daytonfindalawyer.org. And it's exactly how it's spelled there. And the way the internet is now, if you even get close to that, it'll refer to you or refer you to it anyway. We also have a notary public service where if you or some company you work for thinks you should be a notary, or you have a interest in doing that, we have an application and testing service. And did you work on that committee ever?
I did.
I think I did, and we had a lot of folks that were interested in that. And we do need competent notaries. We have a speakers bureau. If you need a lawyer for your organization to come and talk to your members about certain areas of law, we provide that. Again, 222-7902. And maybe the most important program, they're all important, but this is one which is very helpful, is a Wills for Heroes program, where members, volunteer members of our association, create wills and estate documents at no charge for emergency first responders, fire, police, EMT. I'm not sure if we do the National Guard or returning veterans, but you could call and find out about that. So we're doing good work. I'm not taking credit for it. The Bar Association is. I'm giving them the credit, and they deserve it. And the members are public servants as well as attorneys on their own time. So, all right. So back to you in the law and estate planning and probate. Some folks try to design their own documents. I've been talking about the internet a little tonight, and they turn to the internet and say, I could do this myself. I could draw up wills and living wills and things like that. Good advice or good thing to do? Save that little bit of money on a will, or what?
Rather than directly express my opinion, let me tell you a story.
Okay.
I had a friend, Cliff. Cliff had an aunt who had a lot of property, and she wanted to transfer one of them. And at that time, the lawyer wanted $25 to do the deed,
okay,
to create the deed.
Yeah.
She thought that was too much money. So Cliff went online and he drew all these documents, a trust and all kinds of things for his aunt. And when she died, he came to me and we're looking at these documents, and he said, "What do you think?" I said, "No, it's the worst thing in the world. It cost an awful lot of money to get it straightened out. If she had just spent $25 on that deed."
How long ago was that? $25?
Probably 20 years ago.
Just when the internet was starting.
Yeah, and doing a will or doing a deed for $25 was a pretty good deal, I thought.
Yes, sounds like it. I guess what I'm asking is that our viewers tuning in, they can do these documents themselves if they want. There's nothing prohibiting them from doing that. I'm just wondering about the advisability of it. They used to have whole sections in law school about holographic wills and the disasters. What are some of the problems you could get into designing your own documents? Well, you already told us one story, but...
Well, it's... the practice of law is an art, not a science, really. There are certain phrases, certain things that we use that are terms of art that everybody understands. Now, if you don't understand what you're putting down on a piece of paper, it's a formula for disaster. I have gone through some of those documents online and personally, and or in person is a better word, and they can be good, but they are generic. There are, I haven't had a solicitation lately, but what I call the free lunch or the free dinner, and they discuss estate planning, and then at the end they give you the pitch for a whole bunch of documents in a nice little padded notebook for about $1,500, $2,500, sometimes $3,000. And they take a little information, plug it into a computer. This is my personal opinion.
Okay.
I don't want to get into any libelous or slanderous situation.
All right.
And they produce this pile of documents, and it's a trust, among other things.
Mm-hmm.
Most people don't fund their trusts unless they're advised properly to do so. What I call notebook trusts. The notebook trusts I have seen, except for one, have been disasters. Fortunately, in all of those things, there is a clause someplace that says whoever the beneficiary of trust is can collapse it.
Mm-hmm.
And that's the best thing to do probate.
Well, let me ask you, and you've brought up the subject of trust, and as private practitioners, we both know that folks will call up and the first thing they say is, we would like to create a family trust. Mm-hmm. And I'm sure that, well, I shouldn't be sure of everything you say, but generally you would probably say, and why do you want that, right? That's usually a good question. And as you said, there's been a proliferation of that by companies who are probably not lawyers, but what advantage would a family have to create a trust rather than will documents mm-hmm. and powers of attorney for health care? What advantage are they getting, if any? Well,
there's special situations where a trust is really good. To a trust, one thing that a lot of people like about a trust is that there's no publicity. And by that I mean it's not in the probate court. It isn't accessed online, for instance. Mm-hmm. It's private. A special situation, if you have a child with special needs or a spouse or a family member who can't handle money, okay, would squander it or give it to somebody, you can protect that protection of interest in the child or in the spouse or in the whomever. You might not want to give all the money at one fell swoop. You parcel it out. It can earn income while it's being paid out. Mm-hmm. That's a big advantage of it that I see. A trust is not for everybody, and most people don't need them, at least the ones that I see.
Okay.
But
so what you're saying is, I think, if there are complicating factors in your life which are out of the norm, that's something mm-hmm. to think about doing.
Yeah, there's a situation where now that is legislatively protected, you can protect money of a ward who is in a special living situation where they don't get all the money. Mm-hmm. You don't have to go into what Medicaid calls a spend down situation, which that can create more problems than I can think of at this point in my life. But it does allow a direction that is taken care of by a person called a trustee, who makes sure that your wishes are carried out, that lets you speak from the grave. And in a lot of instances,
do that, wouldn't you?
I've done enough talking in my life, I think.
Okay. All right. So in that instance, then, what should the testator be telling the lawyer?
what the situation is with their life. I want a trust. Why do you want a trust? Well, my grandmother's been very nice to me, and she's in a nursing home, and I am very ill. I'm going to be checking out here pretty soon, and I want to be able to see that she has enough to stay on and be comfortable in her life. And when she's gone, I want her to go here to something else, maybe to the children or a spouse. And it doesn't have to be everything. It can be divided up. Children, even if they're competent, as opposed to being minors or having some disability, if they receive a bunch of money at an early age, it may be a great disservice to them, because they might go through it like locusts through a wheat field, and suddenly there's nothing there.
Right.
And except for you and me, a lot of people do that. They just go through it like there's no tomorrow.
Right.
And it controls that. It makes sure that bad judgment will not be exercised.
Okay. All right. Let me stop just for a second to remind you, the viewing audience, that we're live and in color, and you're watching DATV, and this is the You and the Law program, and we are talking about estate planning. That's the number to call, the one that you see right there, 223-5311. Our operators are standing by, and we'll forward your calls to us, which Tom Baggott, who is an expert and has been an expert in this field since 1971.
Yep.
So not that long ago, but long enough to gain a lot of expertise, and can give you, the viewing audience, answers to your questions about estate planning and the probate process. So we haven't talked about the probate process, and what we did talk about, you were a magistrate there for a number of years under the direction of George Ganaris at one time.
Yes.
And were you there when Neil Zimmers was there? And,
I was.
and I don't know who all else. If there was others, you could name them, but giants in their own field, I guess, in their own right.
Yeah.
So you don't need probate until somebody dies. Now, the common theme is when people are designing their estate plan, many times they will say, oh my God, I don't want to go through probate. I've heard horror stories from Aunt Lucy, and those estates went on for years and years. So can we dispel some of those notions as a person of many wars in the trenches of probate? What is the process? What assets go into it, and where do we go?
The basic process is when somebody dies, the will is admitted to probate.
Okay, and now if they don't have a will, cover that too.
Okay. Now let's talk about doing the will for a second. You fill out a bunch of paperwork, you take it over to court, and the executor gets appointed.
Okay. When you say you fill out a bunch of paperwork,
yes.
Is the person themselves, somebody?
They can do it.
Okay.
It takes them a little longer because they,
what you're saying is paperwork is filled out either by the person or by the attorney. The forms required by probate.
Yeah.
Okay.
If there's no will, there's what is called an administration.
All right.
The court appoints an administrator. Now, all this paperwork has to be filled out and submitted, but then there's a hearing to determine who will be the administrator of the estate. If it's not the spouse, maybe it's the children. But if the way things are these days, children get scattered to the four winds.
Right.
And it's awful hard to administer a estate from California, Florida, New Jersey, wherever. So the court's going to pick a stranger to the decedent to administer the estate. Generally, it's an attorney that the court feels is capable of doing it and will do it with honesty and integrity.
Okay.
Okay?
Then what?
Well, then the...
Well, what assets go in? And the reason I'm asking you that is a person may die wealthy but may not have probate assets at all, right?
That's true.
Okay. And how does that take place?
Well, probate assets are assets that are not, well, let's talk about non-probate assets. Okay. A transfer on death real estate, pay on death or transfer on death bank accounts. You can, if you're doing well and you've got a brokerage account, then you can name whoever you want as the beneficiary of that account. You can essentially have no asset that is probatable.
Okay.
And you can have, and by the same token though, there are things that you may want probated so that the expenses of the last illness can be taken care of. The will solve that problem to a certain extent when you have an administration. It doesn't. The biggest problem with an administration of an estate when there's no will is that you have to go to court for everything that needs to be done. I call it Mother May I. Mother May I pay the funeral bill? Can we pay the taxes? Can we pay the court costs? Can we pay the attorney fees? There are taxes due on the real estate. Can we pay those? Because of the way that the real estate taxes are taken care of in this county. So and if you want to transfer the car, if the car isn't titled in the proper name and it goes to the surviving spouse automatically, but you have to fill out some paperwork,
right?
Take the documents over to the clerk of courts to get that transfer title, and it just creates an awful lot of paperwork and time and effort that doesn't need to be taken care of if you have a will.
Okay, so you have a will.
Yep.
The person who owns the will dies. What should the people who are the heirs be thinking about, and what steps should they take?
Okay. Well, the executor who is appointed eventually.
But named in the will.
Yeah.
Okay.
Generally, their duties are to marshal the assets, which is putting everything in a nice little pile, all the probate assets.
Doesn't have anything to do with Marshall Dillon.
No,
right?
it doesn't.
Okay. All right.
No 6 guns or badges.
Okay. Collecting.
Yeah.
The asset.
Paying the bills, like the expenses of last illness, the MasterCard, the Visa, the whatever. And then you make a distribution of whatever's left over according to the terms of the will. Now, that's the easy part of it. Now there's a piece of real estate involved, and Grandma was a hoarder. And so you got to go out to the house, and you got to clean that puppy out. And I had to do that as a young lawyer in a state my father had. And he said, put on an old T-shirt and some Levi's and go out there with a couple of shopping bags. Okay. Go through every piece of paper, newspapers, magazines, whatever. You'll find money stuck in the cracks. I did.
Mm-hmm.
In 2 days, I walked back into the office with 2 shopping bags and $46,000.
Uh-huh.
The biggest bill was a 20, and I was scared to death because I had all this cash. That becomes a problem. We had one, I won't tell that story.
Oh,
But-
we want to hear it.
Oh, it was a problem over in an estate that my partner, Marshall Ruckman, had. We had to force the front door open because of all the stuff. You could hear the mice running around underneath all the paperwork.
Okay.
The young man we hired to clean it out, we were going to pay him by the hour. And he called up and he said, would it be okay if I didn't do it by the hour? Well, why is that? He said, well, the basement, which was a hole, there was no stepward, is full of mice. And he said, I'll put a cage down there and pick them up. He said, the animal store will give me 50 cents a piece for the mice. They feed them to the, and he made out real well.
Yeah,
I thought of getting somebody in there to exterminate them. He said, oh no, they'll go to all the other houses in the neighborhood. We didn't want that. Some of these, I'll call them old bachelors. There'll be a spot from the front door or the back door to the kitchen, to the bathroom, to the bedroom, to the television set, and that's it.
Okay.
The rest is last year's, 10 years ago's newspapers, when I think it was Famous Recipe had you get a $2.50 box, and they'd have to pay the sales tax.
Yeah.
So one fellow I had would throw the change in the box, and when he was done with dinner, he'd just set the box aside because it had money in it.
Mm-hmm.
Those are adventures.
And they sound like adventures.
But you can, with a proper estate plan, and it doesn't even have to be complicated, Mike, you can save your family or whomever more heartache and more frustration. And the cost of probate is somewhere less than 3%.
Mm-hmm.
Now, if you insure your car to make sure that if something happens to it, it's repaired, you're paying more than 2.5–3%.
Mm-hmm.
Same with your house if there's a fire or the roof gets blown off. Probate court oversees all this stuff. They, with a microscope, they have people who go through the accounts, that go through the assets, the inventory, and they make sure that it's done the way it's supposed to be done, the way the testator wanted done.
Mm-hmm.
And it's cheap. Now, you hear stories of, oh, it cost 50% and took 10 years to do the estate.
Mm-hmm.
I did an estate for a man in Holmes County who had 28 heirs on his mother's side and 46 or 7 on his father's side.
Okay.
It took 3 years to do. We had to track these people down. And how do you know that Duke over here isn't Lonnie here?
Mm-hmm.
It's amazing.
Well, what you're saying is the more complicated, sometimes it takes longer because all heirs have to be accounted for.
Yes.
It's not like they're all under one roof or anything like that. Okay, well, you did talk about attempting to do this yourself by people who aren't attorneys. What are the advantages then of this low-cost, more efficient process of getting a reputable attorney to do this?
Well, it's done properly, number one.
Okay.
It's done with, I won't say all haste, but as quickly as it can be done.
Mm-hmm.
Everybody gets their share, and it's over pretty soon. The Ohio probate law requires that all estates be open for a minimum of 6 months.
Okay.
They're supposed to be closed in 6 months too.
Right.
But if there is an estate tax to be paid, which we don't have an estate tax in Ohio anymore. It's
Right.
it's in limbo. It's been suspended for a while. If there's litigation involved in some way or another, you can extend the estate. If certain things just happen and that an estate needs to be extended.
Maybe selling the house or
Yeah,
paying bills or things
sure.
like that.
Sometimes the home is in foreclosure, and which is a long and involved process that has nothing to do with the estate. But if it's in foreclosure, the foreclosure takes a year or so. That can be a complicating factor because it's litigation and something has to be resolved. Sometimes you can give them a deed in lieu of foreclosure and they're happy, but the probate court has to approve that.
What are some you've seen over the years common myths about the probate process and getting through that until everything is complete? Clients of ours, a lot of them have said, I just want this to be over,
Yeah.
whether it's difficult or not difficult. And I understand there's a grieving process to go through also.
Yeah, and there can be complicating factors as we have discussed. But it doesn't take long. If you've got proper estate planning documents and there are no real complicating factors, if there's some bank accounts, a car, a house, there's no reason why it can't be done in 6 months.
Okay, so we have a call waiting here. So let's find out what that's all about. Good evening, you're on You and the Law.
Hi. Hi, I have a question.
Okay.
A lot of companies recently are pushing living trusts in order to avoid probate. What is your opinion on that?
Okay. Our caller says a lot of companies are pushing living trusts in order to avoid probate, and what is your general opinion of that? And we did talk about that a little bit.
Yeah, they're pushing them. And you get a free lunch in the process. I don't like it. You aren't getting legal advice, you're getting documents. If what the lady says is what I understand.
Okay.
They're pushing these things. If you aren't getting legal advice, you're in a world of hurt.
Yeah, let me ask our caller, have you had experience with having done this or been confronted with this and needed to make a decision?
Yes, but it's trusts that take effect during your life rather than after your death. They are pushing living trusts.
Well, living trust, yes, a living trust starts out, right, with during your life, but is supposed to avoid probate and continues on after that. What are some of the things? Sometimes they don't tell you all the things you need to do, like what should be in the trust, right?
Yeah, well, fund the trust. You got to put assets in the trust.
Okay, so all those things that you don't want to go through probate, you would have to take them out of your name and put them in the trust name.
Yeah, put them in the name of the trust, and then the trust has to be administered by the trustee.
Okay.
And in some of these instances, where they talk about a living trust, the person who creates the trust is the trustee.
Right.
And then there are successor trustees if the trustee can't handle it. These guys are in a fiduciary relationship to the trust maker, and they owe that person the highest duty of ethical and proper conduct. So you've got to make sure you have somebody who will do that.
Okay.
And somebody who will do the detail work. If depends on the way the trust is written, but let's say if I can't administer my trust, so-and-so has to administer it for me. What if I have to go into a nursing home?
Right. Somebody's got to decide that then.
Somebody's got to make that
Right.
decision.
Okay.
And
I guess what you're saying is, in probate, and I think you've said this several times tonight, is you get oversight, whereas in a trust you may not, unless the thing gets brought into court somehow or other.
that's right. I had a situation one time, was in a guardianship, but the lawyer came in with a list of expenses, and we as magistrates were checking to make sure everything was okay.
Mm-hmm.
And going through the receipt from, let's say, Kohl's, 3 different sizes of sweatshirts, 3 different sizes of sweatpants, ladies' lingerie, underwear, whatever. And I asked the lawyer, is this Ward a cross-dresser? Because he was a 15-year-old boy.
Mm-hmm.
He said, no. I said, well, look at this. He said, I better go back and check.
Yeah.
Yeah, people try to slide stuff through. The probate court won't let that happen. A trustee may not.
Okay. Let me ask the caller, does that address your question? Do you have any follow-up?
Yes, I have a different question.
Okay.
I have heard of elderly couples getting a divorce in order to protect their money if one of them has to go into a nursing home and be eligible for Medicaid. What do you think about that?
Okay. A caller's wondering, elderly couple, one of them might be ill. What about getting a divorce so they can divide their assets up, maybe protect some of them, maybe getting on Medicaid?
Okay. Well, a person who is incompetent, at least in our probate court, according to the chief magistrate, may not get a divorce. Start with that.
Okay.
Under Medicaid, the community spouse, whether it's the man or the woman, is allowed to stay in the house forever until the incompetent person dies. They get a car. They get $124,000 that Medicaid can't touch.
Mm-hmm.
And that kind of helps out. Now, there are going to be income taxes to pay. Well, whoever's incompetent has to pay their half. Real estate taxes, the same thing. You can spend down a lot of money and not have to really worry about getting disqualified for Medicaid if there's a surviving spouse.
Okay.
If there's no surviving spouse, you have to spend the money. That's all there is to it.
Okay. So I think the caller may wonder how would the divorce help?
It would divide the assets.
Okay.
If you could get away with it, and which is a bad phrase, but it's a term of art.
Okay.
Everything would go to the person who's going to be in the community, and no money goes to the person who's going to go into the nursing home. Medicaid can't fight a court order like that, but there isn't. I don't think a court would deal in that kind of a situation. I don't. They know what's going on. I mean, no.
You mean the divorce court?
Yeah,
okay.
They know what's going on, and I don't think they would allow that.
Okay.
They might.
All right. Does that address your question?
Yes, thank you.
Okay. Thank you for calling. Okay. So we're running out of show here. We're down
that's
to the last
okay.
couple of minutes. And I'm going to give you about a minute or so here, maybe not or so. What last tips do you have for our viewers here about how they should be conducting their financial wherewithal to avoid the most problems.
Well, I hate to tell somebody how to spend their money, but really I think the important thing is to get an estate plan, even if it's very basic.
Right.
Go to a lawyer who is familiar with the estate process and estate planning documents, and get the job done. Do the will. And a lawyer will, rather than just write down some notes into it, they'll talk to you about what do you want to do.
That's the important part,
yeah,
isn't it?
why do you want to do it? You're paying for advice,
Right.
and you might as well get advice.
Right.
And it's very important. You know, there are a lot of lawyers who have an awful lot of experience and who have seen an awful lot of scenarios that they can help you avoid those pitfalls.
Okay. With that, we're going to call a close for tonight's program.
Okay.
This has been You and the Law you've been watching with our expert guest, Mr. Tom Baggott, former magistrate, illustrious attorney here in town. And we've been talking about estate planning and probate. I want to thank all the volunteers behind the scenes who have made this program possible. A shout out to Lily and Katie and Everett, and you should be getting to bed pretty soon. So that's our show for tonight. I hope you've enjoyed it. I've been your producer and host, Mike Monta. Thank you for joining us. We'll see you again next time on You and the Law. Good night.